Anything additional you want to add, Ms. Cheney, about this measure that we've discussed?
I just was gonna respond to Mr. Rogers' comments that,
Oh, I'm sorry, I should have.
that's
allowed you
okay,
to
it's,
put-
it was not the intent to impact the workers' comp statute or the workers' comp act. And I think the specific there would likely control, but we can move on. I do have questions about the title.
And so generally how I like to, is I'm gonna maybe make some changes in dialogue with the board a little bit, and then we can go from there.
Okay.
So, you know, I'm constantly trying to, we all are, but really make these more understandable. It's nothing worse than being out in the world and people talking about how confusing the world of ballot titles are, and I was like, who sets those? I mean, I joke, but they are really confusing, and I oftentimes don't remember what the measure means when I see the title. So I kind of had drafted, and I'll just read this to see what my fellow board members think. Be a change to the Colorado revised statutes allowing a person to recover the total amount of damages awarded by a jury or judge in a claim for catastrophic injury or wrongful death, unless the claim is against a ski area, server of alcoholic beverages, or the state of Colorado. So I think that, you know, it doesn't have the, because what's really important is that, yeah, this doesn't affect settlements with the, you know, it's really, I don't think people realize that if a jury is awarding something, that even the jury's like, oh, sorry, you might award $8 million, but they're getting $500,000. And so I think that really is informing the voter of what this measure does.
Madam Chair, we like your language much better than the draft.
So sure, I'll put it up there, and then I'm open for a dialogue. So it would be allowing a person to recover the total amount of damages awarded by a jury or judge. It's jury, but that's what in a claim, actually, I think it'd be in a lawsuit, sorry. For catastrophic injury or wrongful death, sorry. Unless the claim is against a ski area. And again, the lawsuits, thank you. Server of alcoholic beverages. No. Just, there you go. And then comma, or the state of Colorado. I'm not sure if that totally works, given the Colorado Government Immunity Act, but that's what I was thinking. And then that would be it. And so, the other thing we're not saying in this, which, and we could say in connection there with removing the statutory limits on recovery, because people might be like, well, why don't they, I don't know if the average person understands, like, why wouldn't the jury? So maybe we'll just, because I'd hate to send you off with only one in connection there with today.
So sad.
Eliminating the statutory limitation on damages.
Madam Chair, I might suggest whenever you use the word damages, you put like monetary
Yes,
in
that
front of them,
makes-
because
yeah.
I think some people don't know what damages is.
I had that too, so it would be
Up
under
on
two as well. I don't know if I wanna say like recovery or versus damages, but, so,
I think if you have monetary, it's probably.
yeah, okay.
So what is the,
board meeting purpose.
I'm fine, given the in connection therewith, and yes, you can comment there and after therewith. And I think limitation on 4 should be thorough limitations.
So one concern, Madam Chair, is that we aren't eliminating statutory limitations on all monetary
Right,
damage.
I was just thinking that it needs to say for catastrophic and personal injury.
Catastrophic injury or wrongful death.
Sorry, yes. For catastrophic injury or wrongful death. So, Mr. Bear, are you gonna?
Or we could just take out the and in connection therewith, which would be so nice.
Don't push your luck. Alright. No, it's gonna be my summer thesis. When do we and when do we not meet? But I do think this is helpful. I think it's in very layperson's terms, and I think it's important to note that there is this limitation. I also believe it's important to note that these are monetary damages awarded by a jury or judge, because otherwise, that's where it's most applicable, or it is applicable. Comments, any comments from the board?
Struggling if there's meaning in this.
Sorry, hold on one second, Mr. Attorney. Yep.
I don't think it's a technical correction, but wrongful death is defined, and then catastrophic injury also includes death within its definition. But I don't think there's, death can't seriously limit activities of normal daily life. I think that was a drafting error, but I don't believe
you know, I'm sorry,
the definition of catastrophic injury.
but it says death, dismemberment, permanent injury to the body or mind, or a severe injury that seriously limits activities of normal daily life.
I do think you can die from a catastrophic injury versus a wrongful death. Those are different, sorry, Mr.
No, I agree, it's just catastrophic injury equals death, and then there's also wrongful death in there. It's probably a distinction without a difference.
The other thing I wanted to point out is that we aren't eliminating statutory limitations on monetary damages for catastrophic injury, because those don't currently exist.
Only for wrongful death.
Mm-hmm.
Do we want to say eliminating relevant? That's fine.
Okay.
My team is saying we can leave that in.
Keep both of them in? What do you mean by leave that in?
Yeah, catastrophic injury.
Okay.
I think I may have only had like one title in all the years I've been before this board where we didn't get and in connection with. It's, a bucket list.
Well, it sounds like you already got it. Done, check that off. Move on. Don't, there are not many battles to be picked in this room, so. Fighting one. Oh, you know what? So I had a question. The companies, why does the definition of wrongful death include death caused by a company's or person's negligence?
Well, because I know that in law, person includes company, but we just wanted to include that verbiage in there. It doesn't change that person also would include that.
I mean, yeah. I think it really makes it doesn't make a material difference, but it's, you know, see company as opposed to entity or organization or whatever, but.
And I was just reminded that the statute dealing with servers of alcoholic beverages actually refers to it as alcohol beverages.
Ah.
rather
Oh.
than alcohol.
Okay, any comments on online show regarding the title as it's currently shown on the screen?
No, Madam Chair.
Proposed initiative 2023-24, number 150, the title as designated and fixed by the board is as follows. A change to the Colorado Revised Statutes allowing a person to recover the total amount of monetary damages awarded by a jury or judge in a lawsuit for catastrophic injury or wrongful death unless the lawsuit is against a ski area, server of alcohol beverages, or the state of Colorado, and in connection therewith, eliminating the statutory limitation on monetary damages for catastrophic injury or wrongful death. Thank you. Yeah.
I move that the title board set the title for proposed initiative number 2023-2024, number 150, as it appears on the screen and was read into the record.
Second.
All those in favor?
Aye.
Aye, title has been set.
Thank you.
Thank you very much. So, no applause. Do we want to, the board feel okay to go through one more?
Yes.
All right, now we're gonna jump to 191. I'm just joking.
Oh, I was like,
Um,
what happened?
Initiative number 2023-24, number 175, informally captioned, prohibit certain medical procedures for minors. Darcy and Wade is, and then Wade, Darcy?
He's way down there.
Darcy's right, just want to make sure you're Darcy. Let the record reflect that both of the designated representatives are present. I'm just waiting for someone to shut that off because we have microphones. I realize you're struggling. That's okay, that's okay. Don't worry, we're all working our best here. Mics will pick things up, that's all, so, thank you. Okay, so let the record reflect that both of the designated representatives for 175 are present in the room. If they would like to introduce themselves and let us know what the single subject is of 175.
My name is Dr. Wade Goodall, live in Colorado Springs.
My name is Darcy Sheening. I live in Monument, Colorado. The single subject is prohibiting the medical transitioning of minors.
Okay, so, similar to the discussion we had on the prior measure, or 2 measures ago, I think 149, this measure is, the breadth of liability on this measure is extensive. I'm not sure if it warrants a second subject or if it is something that goes to clear title. I mean, I think with the extending liability to until the minor is 40 years old, even if there's consent, may just really go towards the fact that it's a ban as opposed to single subject. Are there any concerns from the other members of the board regarding single subject on 175?
Madam Chair, question about 2 things that I'm not sure we're raising, review, and comment that would be amended in. Is that better suited for after single subject?
No, I think that's a jurisdictional issue, so we should talk about that now.
Subsection of the measure. Subsection 8B. language is added, notwithstanding whether a minor or a parent of a minor brings a civil action pursuant to subsection 7 of this section. I believe that was in response to, direct response to a question. It's like question 7 that was raised. Is the Attorney General required to bring an action in a case in which a minor or parent of a minor does not bring a civil action? It looks like you also added that the Attorney General has a 20-year statute of limitation to bring an action and enforce that violation.
Yes.
Did that come up in review and comment?
It came up in, comment whether or not the Attorney General was responsible for pursuing if there was no victim that stepped forward. And we wanted to make it clear that the Attorney General still does have that responsibility, but also set a time limit.
The time limit isn't a statute of limitations so much, it's just a clock in which he's mandated to bring this action.
Well, it's both in practice, because if he doesn't bring it within that amount of time, then he can't bring it. I should say he or she.
A second question, subsection 9B. It has an unprofessional conduct, or it looks like a division of professions and occupation disciplinary action for any person who performs, prescribes, provides, administers, or attempts a medical procedure in violation of the measure. I don't believe I saw that in the memo.
You didn't see that in the original set of questions from LCS?
Correct, I didn't see that raised by legislative council staff.
It was raised in their initial set of questions. The council staff, there you go. It's where they ask the question about what is the DA's responsibility, or is there if there's no victim, then how does this become pursued? So that was added to partially satisfy that question. We wanted to widen it and make sure there were a lot of questions about what is the penalty, or, what if there's no victim? So we added these to make it very clear that if a healthcare professional is performing these treatments, then they are subject to the penalty that's listed here.
Mr. Russell, just to remind you, you're looking at 8B, that last sentence? Or 9B, thank you, I'm sorry.
It was
Yeah,
two I raised for 8B and 9B.
So when LCS asked us, what is the penalty? We feel that bringing the penalty, making the penalty more specific in this initiative still satisfies the single subject, because there has to be a penalty when a crime is committed. So if I wanted to write a new law for, you can't steal bread, I wouldn't write two separate initiatives. It's stealing bread is now illegal, here's the penalty. So that's why we included these in this draft.
And I'm not raising for the purpose of single
Oh, okay.
subject so much as, I'm sure you might speak to this better than I, but state law says that any amendments made between review and comment in the title board has to be in direct reaction or response to the questions laid out by the legislative council staff, and whether or not the changes you made here were straying outside the four corners of that review and comment.
Sure.
And so that is in it's either 140, 105, or 106. Just give me a moment here. And so, because the idea is that you want to provide the public notice of what this does, and if
Right.
it's something where we've seen some grammatical errors, just looking at it. And so I think that's a question for the board, because it needs to come before single subject, because it relates to whether the board has jurisdiction to said title, and so, so it's 105, 140, 105, 1, and it's a very long section. Right, sorry. Apologies. Sorry, it's 2. After review and comment meeting, but before the submission, the Secretary of State for title setting, proponents may amend the petition in response to some or all of the comments of the directors of the Legislative Council and the Office of Legislative Legal Services or their designees. If any substantial amendment is made to the petition, other than amendment in direct response to the comments of the directors of Legislative Council and the Office of Legislative Legal Services, the amended petition must be resubmitted to the directors for comment in accordance with subsection 1. So the question is whether the changes in 8B and 9B are responsive to the comments, and generally we include comments that are in the written comment and the things that are brought up in committee as well. And so I think for 8B, the question to me is whether or not adding a statute of limitation of 20 years
Madam Chair, it's
Yes.
not actually adding the 20 years, it's the phrase above that was added.
I apologize, sorry, notwithstanding whether a minor or a parent of a minor brings a
Yeah,
civil
that's
action.
what was
Right,
added.
To my point, Madam Chair, I think that's directly responsive to
Mhm.
question
Yeah.
7.
Yes.
It's the phrase within 20 years I was questioning, is that outside the question? So there were 2 phrases added to 8B in response to question 7. The first clause and then the within 20 years is the second.
right, so I'm sorry, Mr. Gray, were you saying that within 20 years was already there? Let me,
That's my reading.
let me look at, sorry, let me look at the original. 8, oh, the final, oops. 175, 8. The within 20 years was there.
Yeah.
This highlighted version.
And maybe the amended changes, we have another situation like this where so for 8B, if you look at your amended version,
Mhm.
you highlighted it within 20 years, but that was already there. Or you didn't highlight it, you put it in red.
We put it in red, we changed some of the grammar, it looks like we took out a comma, added a comma at the end, so you're right, that should be in black.
Okay.
Madam Chair, I don't think we have an issue there on
Okay.
that one. The 9B is probably the only.
Um, It is important to provide the correct amended, might be tricky, but to make sure we are tracking. And then so under 9, okay, sorry. So 9B is complete revised. And so, apologize, so you added B. Why again did you add 9B?
That, it was to more directly address the question in the LCS hearing, because the question was asked, so is it, what if a healthcare professional does this treatment? And so we wanted to specifically delineate the healthcare professionals with 9B.
So, because I'm assuming in 9A, an alleged violator's appropriate regulatory authority. And so on that language, which is obviously not added, was already there, the liability here is on a healthcare provider I think also the institution, but then also anyone who supports, correct?
What do you mean support? I apologize, can you clarify?
Sure, I'll pull out your language, let me see.
You're referring to our language then, not
Yes.
your support, okay, yeah.
So, because essentially what the point I'm trying to make is that for 9A, you're sort of saying the potential of violators, so an alleged violator's appropriate regulatory authority. And while the majority of the liability rests on the medical provider, it's not, liability is not exclusively on a medical provider, correct?
Yes,
Because obviously it could be a parent,
correct,
and it could be someone who supports.
yes,
And that support could hypothetically be a neighbor who drives someone to a medical appointment.
correct.
And so. A licensee, resident, or certificant. So, if your lawyer's a neighbor, are you reported to the bar? Or is this really just for doctors?
If your lawyer is a neighbor.
Like you're the neighbor that gives the minor and the parent a ride to the clinic?
Well, I suppose we could address that here, but when you talk about attorneys, I mean, that's handled by the Attorney Regulation Council, so I don't,
I'm just wondering who a licensee, registrant, or certificant engaged in unprofessional conduct or is subject to discipline pursuant to this title. Who is it we're talking about here?
well, it could be the physician, it could be the manager of a clinic, it could be anybody who's licensed or credentialed and is involved in this procedure.
So could it be a neighbor who is an attorney who drives the minor to the clinic?
No, because we very specifically spelled out unprofessional conduct.
And that professional conduct wouldn't relate to being an attorney, it would only relate to being a medical conduct?
Correct, yeah. Because that's a slippery slope. If we talked about attorney, then who else are we gonna start talking about? Are we gonna talk about teachers? We're just specifically addressing the healthcare setting.
Yeah, I mean, I think the slippery slope argument isn't one that's well supported by this measure.
Yeah,
So I don't think that's something you should rest on, because if it includes a neighbor for liability and includes liability for 30 years, that slope is as
Right.
slippery as it can possibly get.
okay,
And so this does not say doctor, that's all. I don't know
Okay.
what Title 12 is, but I'm just trying to ask why you added it. Because it says that they were like a registrant.
would it read, but would it be more appropriate to just strike 90?
I'm not sure, I just wanted to pause on that. I mean, I think to me, I read it as relating to it in terms of, oh, you're reporting them to the board, right? So not only
Right.
do they have liability to the board, but you don't say anything about medical physician or the provider providing the care here. And
Okay,
again, it's a broad measure, so, but this, I think the question we're on right now is really whether B was responsive to discussion during the
Okay.
hearing. That's a question for you, so I don't think, but was B added in response to discussion during the hearing?
yeah, there was a lot of discussion in the hearing about, well, who's included in this? Is this for medical professionals? And so we were actually trying to limit it more than we were trying to expand it with this addition.
Okay,
Seems probably the opposite, but
let me take this look back. Do you have any other questions on that, Mr. Morrison, or does that resolve any of your concerns?
I don't believe so, Madam Chair. I went through the review and comment memo, and the only reference to subsection 9 is question 9. The question specifically, what does emergency action mean? Did the proponents consider defining it? This doesn't appear to be in reaction to that question.
Did you say 9?
Subsection 9?
Right, but then, and then question, what was the question?
Question 8.
Oh, question
Yeah,
8.
question 8.
Section, and then the question 8 is, okay, 1230, 123.9, was. then it talks about emergency action. I did not listen to the review and comment on this one, despite listening to several of them. Do you have any thoughts on this, Mr. Barry? So I don't know whether or not, it sounds like it was addressed during the discussion, but I just don't know.
Oh, I honestly don't recall.
So in addition to this, it sounds like pending question on jurisdictional issues, whether there's a substantial amendment in violation of statutes, or the discussions or concerns regarding single subject. I mean, they're separate, but just in terms of,
In the past, Madam Chair, I suppose it's possible this did come up orally at review and comment, and the statute doesn't reflect whether a technical change can be made in reaction to a written versus oral comment. I recall this one was about 10 or 11 minutes long. Yeah, my recollection of it was brief, so 8 minutes. Could take a recess and listen to it, or proceed ahead.
That's a good question. I mean, I think to answer kind of your first statement there, we recently, in the last one or two meetings, we did, I think if something is brought up during the hearing, I would be inclined to include that as something of being responsive and not limiting it just to the memo. It's true that section 2 on 140, 105 is not so prescriptive, but it may be worthwhile to listen to it. Do we believe that it's substantial?
If I could,
Sorry, let me just
oh,
so
go
that
ahead.
one done. I mean, I guess one thing is that 1A does already say that the alleged violator's appropriate regulatory authority. I don't know if it is drastically different than what they're doing in 9A.
Madam Chair, I think this may also actually be in response to question 2. What happens if a healthcare provider performs a medical procedure? And this seems to relate to a medical professional and what happens if they perform. So I don't.
Yeah. It does seem reflective of that. I just. Okay, I think we're inclined to find that it was responsive to your comment, but that there may be a time where we do need to take a recess. So with that, I'll entertain a motion on, and I'm sorry, did you want to, I apologize, did you want to make a comment?
No, it's okay. I was just gonna add that it is a bit redundant. There were several questions asked about the penalty. As you said, Mr. Berry, is it? Question 2 had several different questions wrapped within it, and it was a quick hearing, so there were a lot of things addressed about the penalty pretty quickly. But we're open to, I almost feel like it's redundant anyways, so it might be.
So I think with that, I will entertain a motion on single subject.
And I move that the title board finds that proposed initiative number 2023-2024, number 175, has a single subject and that the board has jurisdiction to set a title.
Second.
All those in favor?
Aye.
Aye, that motion passes. The board has jurisdiction as a title. Much like my statement in the prior measure, I'm inclined to try and make this more of a layperson term. I'm gonna start suggesting some amendments. I realize these may not all stay, these might not be ones that everyone likes, but, so I would say performing on two, after performing, leave performing, gender affirming surgery or medication. I don't know if we need more than, and then I would. Hold on a second. And then delete all the way to and in connection therewith. And then, imposing after therewith on 4. Liability on the healthcare provider who performed the procedure. And any person who assisted until the minor is 48 years old. Or 10 years after their death. And then semicolon. A healthcare provider is liable. Oh, sorry. Even if the minor and parent consented to the procedure. Allowing a semicolon. Allowing any person to advise the state's attorney general of a prohibited procedure. And requiring the attorney general to file a claim for up to $20 years after the prohibited procedure occurred. So let's see, it would be only in person to advise. To file, I think it would be a lawsuit instead of claim, sorry. So on 8, replace claim with lawsuit against, instead of lawsuit against the provider or anyone who assisted. Where you are, yeah. For, yep. And then it would be for up to, not or, for. Okay, I wanna make sure that gender affirming surgery or medication isn't, what did the term that they used?
I'm sorry, line 7,
Yep,
that should be advise, not advice. And it should be a prohibited, not prohibitive.
no? Oh, there already. I mean, I think, I don't think we can say it's a ban, but, I think we really need to show that there's pretty extensive liability in terms of duration. I think it's also the fact that you can't, even if you've consented, and the death of the minor is also very broad in terms of, so it seems like there could be liability if it says, this is 7C, the parent or next of kin of a minor may bring a wrongful death action against a healthcare provider alleged to have violated the section if the injured minor is deceased and the minor's death as a result of the physical or emotional harm inflicted upon the minor by the violation. So if the child had gender affirming surgery and then someone committed a hate crime and killed them, I think you could sue the doctor. That is what this measure allows. But to me, the duration of the consent, the duration of the statute of limitations and that consent is not, I guess, an affirmative defense or, and then I think you could delete the rest of it. I don't know if there's anything in there that, does the board have thoughts about what I have suggested? Do you wanna?
If we go up to the start, I think it needs to be performing gender affirming surgery or medication on a person under 18 years of age. We don't have minor anyplace in that.
Oh, right, thank you. And so does this define minor?
Minor's defined in the definitions as one
18.
under the age of 18.
Okay. Thank you, that is a good
And I
correction.
think it's just under 18 years of age, you don't need the age.
Also the liability in terms of anyone who assisted, I was looking for this earlier. Sometimes people put footnotes on, page numbers on their motions, and that is wonderful. I encourage all of you to adopt page numbers, especially if you file in March or April.
Sorry.
So, hold on a second, let's see. Continue, get ready. So, stress exceptions. There are some exceptions, but I don't think that's gender affirming. Are you forgetting one now? Let's supersedes. Non-offense. Let me see, any person not knowing a person shall not know the provider. I think the medication's probably clear, right? It's not compliance, right? Okay. A minor, the parent of a minor, injured as a result of a violation, may bring a cause of action against a healthcare provider. This is the Department of Forces. 7A, healthcare provider, or person or other entity alleged to violate this section. Or healthcare provider, person or entity that supported the alleged violation of this section. And again, this is really broad, and so this is a question for the proponents. 7A, and it says, or other entity that supported the alleged violation of the section. That is, it doesn't say, I don't know if you're referring to medical staff, I don't know if you're referring to just the receptionist, I don't know if you're referring to the neighbor who
I get what
drove you.
I understand. We're referring to medical staff. That could be anyone from the physician on down to the person who came in and, took vitals. So the nurse, the LPN, whatever you want to call it. But no, attorneys, neighbors in this right here, no, I wouldn't say that applies to them.
When you say right here, you mean 7A?
Yeah.
But so if two parents and the child consented when the child's, 14, or 17, and then when the child's 45, the parents are now divorced, one of the parents could sue if they they could sue the doctor.
That's correct.
And then a minor, the parent, and then, but not next of kin, the next of kin is only for the wrongful death.
Yes.
And then, I guess I just don't know if this covers the death of the child, result of physical or emotional harm inflicted upon the minor by the violation. I don't know. Questions? Do you wanna, maybe just for a moment, Cheryl, do, no track changes, I might read it, but if the board has any questions or thoughts?
Since we talk about minor, in other places, maybe on line 2, the person should be a minor under 18 years of age.
Could you just say a minor?
A minor is defined later on.
I think you wanna say minor instead of person?
Okay, sorry.
And should it say performing surgery or providing?
Providing.
Okay, hold on, just, that's okay, I know it's hard, but, it helps with that, but, sorry, Mr. Mayor, I didn't intend to repeat flow here. Before medication, sorry, I'm not there. Thank you, Cheryl. Oh, and healthcare is hyphenated in one place and not in the other. I think you probably don't need it hyphenated. So take out the hyphen. There is some things about disclosing profits and damages, but I don't know. I don't know if that's one just by open. Prohibition on healthcare. So concerning, or should we just say instead of just prohibiting, instead of concerning any prohibition on, just say prohibiting a healthcare provider from performing? And then take out on. And then at the, before performing, on the first line. And then we have I suggested gender affirming surgery. The proponents also had said prohibiting the medical transition of minors. I don't know if Board has thoughts on what terminology maybe best.
That might be better than just providing medication.
Keep gender affirming or,
Yes,
okay, or providing the medical, well, yeah. It would be the medical transition. The only thing, interesting, I don't know, I feel like puberty blockers are somewhat well known. Or the medical, so would we need to say performing gender affirming surgery on, or the medical transition of? I kind of like medication. I think I would either include them all or, because I think medical transition still sounds surgical to me, where medication.
Medication transition.
Because I don't know if if medication transitions as opposed to suppresses it's like a puberty blocker, so I'm not sure. What do you think, Mr. Morrison? Do you like the medical transition of, or, providing providing medication. So what was it showed before, Cheryl, before the medical transition? Maybe can you say performing, yeah, so maybe performing gender affirming surgery, comma, medical transition. Or providing medication. Not too much. We need to switch some of the ons and ors and ofs, but. I generally think we are there.
I may go back to performing gender affirming surgery or medication.
Or providing, okay. So then would we say performing gender affirming surgery on or providing medication to? I don't think I have any other comments, is it board, or I'll open up the proponents to respond to this.
Would we be able to change gender affirming surgery to gender transitioning surgery? It is not our belief that it is gender affirming. That's not a term that's based in science.
I think that's okay.
Okay, thank you so much.
Yeah. Transitioning. Yeah. That is. Edit.
And with that,
Okay. And so for the board, I think it's, clear that it's 30 years after they're 18, so you're saying until they're 48, seems more clear. Are there any comments or questions on the board on the draft?
Madam Secretary,
Yes.
it's 20 years. So it's, you said 30 just a moment ago.
Oh, and also too, I'm not the secretary, but thank you. Thank you for the vote of confidence.
so would it be until the minor's 38 years?
Yes, I think that's right. I'm sorry. I apologize. No, within 30 years of the date of the minor's 18 years of age, and so that's,
48.
yeah.
Okay,
So that's
Okay.
7.
Thank you.
Thank you.
No.
And 20 years was the Attorney General.
Correct.
Any questions on my mind?
Madam Chair, I do not see any hand raised.
Okay. Proposed initiative 2023-24, number 175. The title as designated and fixed by the board is as follows. Be changed to the Colorado Revised Statutes prohibiting a healthcare provider from performing gender transitioning surgery on or providing medication to a minor under 18 years of age and in connection therewith. Imposing liability on the healthcare provider that performed the procedure and any person who assisted until the minor is 48 years old or 10 years after their death. A healthcare provider is liable even if the minor and the parent consented to the procedure. Allowing any person to advise the state's attorney general of a prohibited procedure and requiring the attorney general to file a lawsuit against the provider and anyone that assisted for up to 20 years after the prohibited procedure occurred.
Okay, I move that the title board set the title for proposed initiative number 2023-2024, number 175, as it appears on the screen and was read into the record.
All those in favor?
Aye.
Aye, that title has been set.
Thank you.
Thank you so much.
So with that, I needed a break. And I think we're having a change in, the title board membership. So, we will resume with initiative number 197. I'm afraid it is 143. Can I just say 3? Alright. Was it? Yeah. And then